There's a lot of stuff that kind of happens below the waterline that sometimes doesn't get so much attention. And these 4 cases are perfect examples. As you know, any of you who have been following the work of NCLR for any period of time, the most heartbreaking cases that we're involved in are cases that involve children and their parents. And when those children are taken away from those parents, or those parents lose custody or visitation. It used to be, when I first started, and this was only 16 years ago, that parents lost custody of their kids based on sexual orientation to a homophobic spouse, ex-husband or ex-wife, represented by some lawyer who, just thought they were doing the right thing. They weren't necessarily anti-gay, they just had a paying client. Well, now that's entirely changed. Now, most of the combatants in these cases are both parents to the child, and they're both members of our community. These lesbian versus lesbian mother cases are just heartbreaking. The good news is we've been involved in winning 2 of them in the last 2 months. Now, I've been here long enough to see and to be on the other end of these cases. And what they mean is that these moms who, with their co-parents, with their partners, helped raise these kids to sometimes the age of 5, 6, or 7, lose in court because they're held to be legal strangers to their own children. And they don't see their kids again. So when we win these cases, and that relationship is preserved, and these women are considered to be mothers, regardless of the fact that they're not biologically related to the children or the parents weren't married, these are huge victories. They're huge victories for the kids, they're huge victories for these parents and our clients, and they're huge victories for just humanity. So we're very excited that it seems to be that maybe over time the tide really has shifted, and I want to be in this work long enough to see a day where these cases just don't happen anymore. You function as a parent, you have a child together, you agree to be parents together, the law will never allow that other person, that other parent, to say that you are not a parent or that you can no longer see your child. We also settled another very important case that grew a little bit out of the Prop 8 debacle. After Prop 8, we had people in this limbo situation who got married in other states and then moved to California and didn't know what their legal status was. So we helped to draft a bill, SB 54, and it was passed by the California legislature, signed by the governor, thanks to the great work of our partners at Equality California. And that bill makes it very clear that if you married out of state during the period of time that weddings were permitted and marriages were recognized in California and moved to California, you have all the rights and benefits of a married couple in California. And that became very important in a real-life case, and this is what it's all about. A firefighter in Alameda County and her partner got married in Canada, moved here, and she was told she couldn't put her partner on the health insurance through the Alameda Fire Department. Well, that's wrong. And the good news is, without having to file a lawsuit or making a federal case out of it, we were able to work with the California agency that administers these benefits, and now our firefighter, Nancy, her partner is on her health insurance. We love news like that. We also want people to know about a case, a little bit of an update, sort of where are they now, for people who have followed our work closely. We had 2 clients in Florida several years ago, Sheila and Joy. Sheila and Joy, at the time we represented them, were in their 50s, 60s, but they were thinking ahead, and they were planning how they would live their retirement. And they wanted to buy a unit in a facility in Florida, in their hometown where they were living, as a couple. And the facility would not sell them a unit as a couple because the facility would not recognize their relationship. They could have purchased 2 separate units, and in fact the facility said, and we'll put them right next to each other. But of course they didn't want 2 apartments, they wanted 1 apartment where they could both live as a family. And again, we were able, without a full-blown lawsuit, but with the threat of one and the law, we believed, on our side, to work out a settlement with the facility. They sold Sheila and Joy their unit 3 years ago, and next month Sheila and Joy are moving in to their retirement apartment as a couple, recognized as a family, and secure that their relationship will be respected and recognized. That's all we really want. Dignity, respect, recognition, huge. Finally, and for people who want to know more about this work, especially this family law work that I've been talking about, because this is, for so long, has been our sweet spot. You know, this work is right in our wheelhouse. It's what we do. It's how we were founded, to protect the rights of lesbian, gay, bisexual, and transgender parents. But for any of our work, on our sports area, in our immigration work, in our elder work, go to our website, www.nclrights.org, and see case updates like this, get information about legal questions you might have, and most of all, hopefully, be inspired at what we've been able to accomplish, not just in the last 2 months, but in the last 32 years. And it's because of you. Thanks for your support.